Welcome you all to the second lecture on the lecture series on corporate law. In the introductory lecture, I just discussed the purpose of the company and why the company is separately advantageous and how it is different from the other legal entities. For this discussion, for this topic, I will be discussing, throwing some light on the primary document which is necessary for the incorporation of company. Because if anyone wishes to incorporate a company, they are supposed to prepare a document, and that document is the Memorandum of Association. Memorandum of Association is one of the most and primary document. Again, I introduce myself. This is Professor Kondaiah Janalagadda, Professor of Law, and who has started the legal education, that is access to legal education, and the lecture series on corporate law. The important document according to the Companies Act, the Memorandum of Association is defined under Section 2, Clause 56. According to Section 2, Clause 56, MOA means MOA of a company originally formed as altered. That means if the company is being incorporated today, the company has to bring a document which is incorporated one, the original document. In case of further changes, then we call it as altered. According to the Section 4 of the Companies Act 2013, the MOA contains 5 subclauses, or the 5 components, or we can say 5 characteristics, or the 5 ingredients. Among them, the first one is the name clause of the companies. So whenever a company is being incorporated, if the company has to write end of the name, if there is XYZ Private Limited, in the case of Private Limited, in the case of Public Limited, they will write it XYZ Public Limited or the limited companies. So the name makes us to understand this company comes in the particular cadre or this particular type. Now everyone will think out, this we all know very well, the MOA has to be prepared, a company should get a name, the name is being, there should be a name for each and every company. It is as simple as that. Then another thought-provoking question will come. Why should we discuss this particular clause? What are the implications comes under the name clause? So my dear viewers, the name has to be identified and get registered with the ROC, and the legal implications are such, when you identify the name, there is a process to identify, and there is also a certain regulations how you will identify the names. Let us see what are those regulations, how to identify the name. I just thought of sharing some of the products which are part and parcel of our life. One is namak, that is a salt, other one is the pencil, right? It starts, both are the part of our regular life. When you're talking with regard to the pencils, which is very close to us, is the Nataraj pencils. And majority of us may be thinking Nataraj pencils are produced by Nataraj company, unless otherwise you open and see the one side of the cover, the name of the company where it is written Hindustan Pencils Private Limited, right? And other one is Tata. Everybody says Tata company, Tata company. It is one of the, Tata is a part of everyone's domestic life. No one say that I don't know the Tata groups. But we not the Tata mobiles, Tata Pharmacy, Tata Chemicals. When you see the Tata Salt, it is produced by Tata Chemicals Limited. So therefore, there is an importance where the name says it is a private limited company where you have the 2 to 200 members, and it is also a public company where the member 7 to unlimited, because it makes the investor or the consumer who is approaching the company for the investment purposes, or as a consumer when they approaches, they can understand the nature of the companies. Now, how to identify the name? And people may laugh, say that, no, we know that, what is big deal? We can identify the name. We go to some people whom we know, they will give the names. Because name has very important thing in our life, because name has its own brand. So the name, when you are identifying, there is the rules which provide under the Companies Incorporation Rules 2004. Under rule number 8, it provides how to identify the names. And the people who are incorporating, or the people who wish to incorporate a companies, who are watching this video either immediately or at some point of time, kindly visit this particular website for future updates. Because company law is such a subject where there are series of, or where there are huge amendments will come, updates will come. And in this website, we have another application is called Spice Plus and the Spice Plus Plus, where the application based incorporation of companies, which makes the investors or the promoters to incorporate a company. Now, another important concept, how to identify the names, where to get it. A name has something called which are permitted by the law, which are not permitted by the law. Rather, a permissions and the prohibitions and the restrictions. What is permitted, what is not permitted. Let me put it in a simple way. ABC 123 at the rate 2% limited. In this name, we will see these alphabets, numericals, symbols, and special characters, and symbols and special characters, and also the numbers. These type of the names are now not permitted, because the name should contain some meaning, or name should be permitted by the registrars, where it should be very specific oriented. That's what the law says as of now. In future, if the government changes, maybe we can go for the as it may think. Secondly, the name should not be identical to the existing companies. That is very important one. For example, when you say for example, the name of the companies, you can say that BMC or BMCE. So sometimes very similarities and the one letter changes, which changes in the pronunciations, right? The pronunciation comes in a similar way, BMC and BMCs. So it lies in identical names. When you are pronouncing the company name, it is not possible to differentiate what is the product that there in the market. When you go to the market, some of the companies will have a similar identical names, where either the investor or maybe the consumer gets confused and gets trapped into the different fraudulent transactions. So therefore, one of the prohibition is that a name should not be identical and resembling to the existing name. The other one is that name should not be undesirable name by the central government. Undesirable names are given by the central government time to time, which always presents the nationality and the name of a particular state. So if the central government provides the rules and regulation, if this company has a particular name which is resembling, then they say that no, you cannot have this particular name. And the third character is that if any local authority, if any state government, for example, if there is a company called XYZ Municipal Corporation Limited, because municipal corporation is again the local authorities and the state entities. So a name should be one which has been selected by the promoters. The promoters have the complete choice. Promoters can select 3 names and they can register their names well in advance, and they can also go for availability of the names. So the facility is available, so they can go and see that whether a particular name is available or not. Then after that they can decide, okay, this company name is available, therefore we can go for the selection of the name. And therefore the law says that if the names which are identical, names which are undesirable, names which are connected to local authority, then law comes as the prohibitions. So we are talking about the legal aspects of the name. The selection of the name is the discretion of the promoters or the founding people of the company. They have a choice to select the name, subject to the availability of the name, subject to the not contradictory, and permitted by virtue of law. If it is permitted by virtue of law, by virtue of the rules and regulations, the name can be selected. So the law says this is the procedure, follow the procedure, identify the name, then you get incorporated your companies. So the first and foremost clause is about the name. The legal implications of the name is that how to select the name and how not to select wrong name. So please remember how to select the right name, how not to select the wrong name, and involve in the different process. So let us understand about the importance of the name. The other clause where lot of jurisprudence has been developed, lot of legal issues comes before the court of law about the register office. Register office means the company in which place it is being registered. For example, if the company is being registered in a particular state, say for example Delhi, or say for example Maharashtra state. In Maharashtra state, if the company is registered in Mumbai, right, in particular address they have taken a particular street. So when you identified your address, you created your office in Mumbai, in Maharashtra. Now laws of Maharashtra will apply as far as the tax is concerned, number 1. And company gets the identity by virtue of registration, or we call the registry, because the company belongs to a particular what is called about the domicile or the nationality. And another very important concept, the members of the company, shareholders of the company wishes to see how the company is functioning, where the company is there, they can visit this particular office and see this office, right? So if the shareholder is there who invested in a company and the shareholder wants how the company is performing, let us go and discuss with the management. Then where to go shareholder? Which address he will go? So company law provides under the register office, various provisions are there. They can go to the register office for the legal issues, for any complaints and the grievances. The another important clause, the company has to conduct annual general meeting where they provide the dividends to the shareholders of the company in the jurisdictions of Mumbai itself. If the company is there in the Mumbai, they are not supposed to conduct the AGM in Delhi. That means the people will come to know, the people in the sense, the shareholders are the members of the company, the shareholders and the members of the company will come to know that there will be an annual general meeting. In the annual general meeting, we will come to know that how the company is functioning, and the annual general meeting is going to happen in Mumbai because the register office is in Mumbai. This is very important concept. The other concept is that, or other ingredient is that all the legal notices, right? all the legal notices has to be filed or sent to the registrar office, because the jurisdictional issues to context the case generally arises in the Mumbai itself, because the registrar office is in Mumbai. The people who are dealing with the company should well versed and well advanced should know that this company is in Mumbai. If any dispute is arising in future, I have to file a case in Mumbai. That's one of the point which talks about registrar office. I am just highlighting in the section 4 the legal aspects of the Memorandum of Association. I am not discussing elaborately on secretarial practices. That we will discuss what is there in the what we call in the the schedule 1. So we are talking about the how the law deals MOA, because MOA is a printed form which is available and given under the schedule 1 of the Companies Act. Therefore, there is nothing to discuss too much about on the aspects. But when we are reading from the legal perspectives as far company law is concerned, the fundamental question comes to us is that, sir, why should we read the MOA? What are the legal issues arising in the MOA? So another issue which is arising in the registrar office is that registrar office also determined about the domicile and the residence of the companies by virtue of its incorporations, and where these applicable comes to the tax laws. So where the company has to pay some tax duties and the land revenue laws, so the law will be applicable to the where it is being registered. And another important comes a company which is registered in one particular place having multiple places its ventures. Say for example, company is in Mumbai, it has the branches in USA, it has an office in UK, it can have an office in Sri Lanka, then what can be various laws applicable? So these are all comes by virtue of one called as the incorporation, where the company is being incorporated. So the number 2 is that registrar office of the company, and it is up to the promoters to select the registrar office. Company law is very silent on that. Wherever the state you prefer, you can select your registrar office. Clause number 3. Clause number 3 is another prominent clause. The basic purpose for which you are commencing your company. For example, you are commencing your company for the manufacturing of the laptops, manufacturing of the mobile phones, or manufacturing of the cloths. The company have to specifically written, this is an object of my company. Therefore, a company which is incorporated for the purpose of manufacturing of a cloth cannot enter later for the manufacturing of the automobiles. A company which is incorporated with an object of automobile industry may not go for a manufacturing of the cloth industry unless otherwise objects provides. This company can do the production of the automobiles and also do the production of the particular objects. Because objects only decides for what purpose the company is being incorporated, what is the nature of an activity. And you may have a doubt. So what will happen if the company does an activity which is not permitted by objects? That becomes an act called as ultra vires. And any act which is done by beyond the objects is not enforceable. So the people who are approaching the company should be very careful whether this particular contract, whether this particular activity is permitted by law or not. So object clause always talks about the limitations of the companies. That is one important. The other important concept in object is that in the Companies Act, we find in various places one of the terminology called best interest. Now, when we ask ourselves what is meant by the best interest and how the company achieves the best interest of the companies, the common man understanding people will say, sir, best interest is what is that? Is as simple as this. Best interest means that we go for the achieving of the profits, maximum gain, providing the more profit to the shareholders. This is already there. But important more than profit is that achieving the objects of the company comes as best interest of the companies. Because the best interest of the company is not always achieving of the profits. Profits are the regular product of the any business venture. The primary object of the business venture is the profit. There can be a business ventures which are object oriented, which are service oriented, which are larger interest oriented. So the objects are promoted. This is the when the company comes in existence, they should very specifically have to tell objects means the purpose for which company is being incorporated. Then moving on to the fourth one, that is liability or the guarantee of the subscribers. Who are the subscribers? Subscribers means on the day one, if you are incorporating a company, the 7 people of the public limited company, so you are having the 7 people are the subscribers of MOA. So then there are the 7 people who are the subscribers of MOA. They write it, what is their liability. What is the liability by virtue of capital or the guarantees. Then fifth one is the capital clause. So the 5 clauses I will be showing you in a very few minutes in the course of my presentation how it is given under the schedule. Maybe I will go back and I will try to put it. What are these schedules, right? Now it is visible, right? Schedule number 1 of the Schedule 1 of the Companies Act 2013, which makes a template, a format is given. So job of the lawyers are very easy, or any secretaries. You need not to prepare again and again. The memorandum is already printed. The memorandum is already there. You are supposed to fill up the name, address, objects, some paragraphs. Then what about the liability and who are the people who are subscribing? And this subclause also is given about the how many people are given by virtue of the merchant signed before whom, by affidavit, signatures. So the company law is drafted in such a way, whatever the doubts we get, whatever the clarifications we require, if we do some little bit of understanding of the subject, you will get very easily to understand. That's why when you see here, they have written the names of the shareholders, like for example, AB merchant of so and so, and the 7th one. So the names are already given under the schedules. Now we understand there are clauses, right? The clauses are the 5 clauses. The 5 clauses are the name clause, register office, objects, liabilities, and the capital clause. Once you incorporate a company by writing of these clauses, the another clarification comes. Sir, if I want to change, if I want to alter, what are the provisions given to us? The provisions for any changes, right? Nothing is permanent in this world. The date of birth which has also has a date of death, like what we call the dissolution of companies. If the company name is being selected today, if the company wants to amend the memorandum, all the 5 clauses of memorandum can be amended under section 13. Section 13 of the Companies Act provides the procedure by passing of the resolution, order resolution, then you can go with regard to the alterations. Section 13 clause 2 talks with regard to the change of the name. At any point of the time, if the company wishes to change the name, it can go for a change. That means the first subclause of section 4 subclause 1. Section 4 subclause 1 is about the name. So the name can be changed at any point of time by adopting the proper procedure of the law. In the similar way, section 13 clause 4, if the register office, as I told earlier, if the office is in Mumbai, if from Mumbai you want to shift to the Bangalore, because there is a change of the state, that is from Maharashtra to Karnataka. So if there is a change from Maharashtra to Karnataka state, then it can be amended under the provisions of section 13 and clause 4. And similarly, object clause. If the venture of the company is going to be changed and business nature of the company is going to be changed, then you can amend. In the similar lines, you have the section 13, clause number 11. So the point which is very brief way is that the amendment of the provisions are given under the company's law, and those companies which are provided to you is that section 4 and 5, which talks about the contents of MOA. Section 4 talks about the contents of MOA. Section 13 talks about the alterations. Then you have the section 4 read with the schedule number 1, right? Section 4 and schedule number 1, the format is given to all of you, how the company has to be understood, followed by company's names and the regulations under 2014 and the SPICE++ applications, right? In brief, all these try to provide you how you are trying to identify the MOA, how you going for the incorporation of companies. MOA is a simple document and which has huge legal implications. In those legal implications, we have the theories of doctrine of ultra-vires, doctrine of intra-vires. Then you talk about the powers of the company, whether the director's powers, etc. and all. For those things, I will try to record another lectures. Let us see that how the audience or the people who are listening this lecture or who are listening to my topic of discussion today and how they try to react accordingly. I will try to record further lectures, and I will try to introduce the same lectures in the future course of my what's called the discussions on company law or lecture series on company law. This lecture is only to introduce you the first document for incorporation of companies, MOA. I request all of you kindly put your comments if any comments are there, and kindly provide your constructive feedback. Therefore, I can try to develop and clear your doubts. If any one of you have any of the doubts, kindly put it in the box. Then in further lectures, I can try to come back with the feedback and the doubts. These are only experimental basis, which I try to introduce the subject of law to the people who are not having the complete access to understand the nuances of the law, belong to the legal fraternity and part of the legal fraternity. I take this opportunity to introduce these lectures, and I will try to meet you on further lectures. Thank you all. Take care and bye.